Hey everybody. CJ, I made you co-host. I think it allows you to see if people use the raised hands, but we've been pretty good with the comments, but just in case.
Cool.
And we can wait another minute or two and see if people roll in.
All right, cool. So did the link I sent you earlier work, Dr. Myers?
It did, yeah. All right, well, we'll go ahead and get started. Just one thing, I'll send you all an email about this when I officially do it, but I don't know about you all, but I'm reading as we go with you all, since it's my first time prepping the class. I do that, so it's fresh in my mind. And reading 2 chapters from Fisher was a lot. So next week you're supposed to have 2 as well, and I think there's some other weeks. So I'm going to go through and revise the syllabus so that doesn't happen again, or just the schedule. And I'll send that to you either this afternoon or sometime tomorrow. So everything for Monday should be fine. But next Wednesday will be a little bit better. So I apologize. And thanks, CJ, for tackling so much material. So with that, I will turn it over to CJ, who is our leader today.
Thank you. Good afternoon. Well, good morning, everyone, I think. So we're just going to get started with our usual Wednesday stuff by doing the discussions in groups. And how do you, I sent the link in the chat. So how do you,
So yeah, I don't know if you'll have the ability to do this or not. So take a look down at the bottom of the screen where it says more. When you click on that, you might have breakout rooms. If you don't, I can do them.
Yeah, you have to do it.
Okay, cool. So let's see, there's 13 of you here, so I'll do 3 groups to start. Oh no, wait, there have to be 4 groups because there's 4 things. So they'll just be smaller than usual, and as other people come in, I'll put them in the groups. So, and do you want 20 minutes, CJ?
Yeah.
Okay. Alrighty. So all the same stuff as normal. And CJ, you'll be assigned to a room too. So
Okay.
I am going to open all the rooms.
If I'm talking and you hear a big thud, it's because my tortoise is trying to climb his cage in order to eat plastic leaves.
Alrighty, I think everybody's in.
Is that like the first person back? Oh, okay.
Is my screen sharing with everyone? Okay, cool. So this is, not gonna lie, this is like a lot for each one. So we're just gonna go through all of them, and we're gonna do it how we usually do it. If one person wants to speak from each group, then they can. That would be beneficial because it's literally a lot to cover. So let's start with group one.
So there was a therapist who had sessions with Miss Simpson, and after she died, she disclosed information that wasn't asked for. So she had no reason to disclose this information without cause or reason.
And then the portion of ethics codes that were applied here were, we said 4.01, it was just maintaining confidentiality. And then it could also have been 6.2, maintenance and the disposal of confidential records. And then 9.01 was the basis for assessments of the information recipient.
And then what should she have done differently? She just shouldn't have made these comments without being asked for them, or yeah, no informed consent for them.
Okay.
And just quick note on this case. So the book that I get these cases from actually has little blurbs afterwards when they're real cases. So she was barred from seeing patients for 90 days and placed on an additional 3 years probation as a result of this. And she falsely represented herself as a psychologist in television interviews. And the woman tried to fight it, or said like, oh, I didn't violate confidentiality because she was dead. But she didn't try to appeal because she knew it'd be a costly legal fight. So yeah, these things have consequences.
Is there like a time period for dead clients before you can disclose information, or you just never disclose them at all unless, because my question was, had like a court system or like when there was testimonies, I would think you would be able to disclose them because you're under oath. But in terms of her case where she wasn't under oath, or even it was just kind of random, is there like a time period for when a client is dead that you could disclose that information, or should she just not have said anything?
Yeah, Zoe, based on what you were saying, essentially it's like your client is alive. Like you shouldn't just randomly suggest it. You know, if you get a subpoena, you're asked to testify, certainly you can talk about it then. But it's not like, oh, the client's dead or they've been dead 7 years, so now I can just throw their information all around, right? So yeah, really good question. You should essentially treat it like the client's alive in terms of ethically and legally disclosing things.
All right, I did not know that. I thought there was a certain time period where you can request information and then like if they give it to you or not.
That's a really good point, CJ. Yeah, like anyone can request information, right? And the estate can, you know, Nicole Brown Simpson's, you know, the survivors could have requested it, just like they can request it when you're alive. And then like the psychologist should essentially work with a lawyer to make sure that it's okay to do it.
Let's go on to the second part.
So this one was really hard to understand. If you could just scroll up a little, yeah. So basically there was a police officer, Redmond, who, she was responding to a call and she fired her weapon and killed Allen Sr. And so it says, as he pursued, rapidly gained ground on and stood poised to stab another man with a butcher knife. It's not well written because it was a little confusing to understand, but she shot him and killed him. So Redmond, the officer, went to go get therapy, and it says that Carrie is acting as an administrator on Mr. Allen's estate, sued Redmond, citing alleged U.S. civil rights statutes and Illinois tort law. And Carrie wanted access to the social worker's notes and wanted the therapist to give oral testimony, whereas Redmond and her therapist refused. And so the trial judge told the jury that refusing to provide that information, it would be held against Redmond. So that's the summary. It was really long, and we kind of had a harder time with this one. You can scroll up if you don't mind. Thank you. So we were looking around, and we think that the ethical problem was the use or exploitation of social work used against the officer. We think. We're not entirely sure, though. At least I'm not.
That was it. Oh, was that all?
Okay, then for, oh, are you going back up? Okay. The ethic codes that we said applied here was 4.01 about maintaining confidentiality, 3.07 of requesting for party services, and 9.04A, which is the release of data. And then, like we said, we were unsure exactly about what the ethical problem was. So we weren't exactly sure what the mental health professional could have done differently. We kind of came to a consensus that the therapist had made the right decision about not testifying on behalf of the client, just to maintain, not have multiple relationships, but also to not disclose information if it could potentially cause harm to like the client or patient. But yeah, I don't know if anyone wants to add on to that.
Yeah, follow up to this case. So this went all the way to the US Supreme Court, actually. And they ruled that essentially you can have what they call privilege. So the therapist didn't have to disclose that information, and they were wrong to hold it against the person on trial because of it. So this really like set a precedent for privilege, which we typically in the legal system think of as like attorney-client privilege. It extended that to therapists. So.
Okay. Thank you, Group 1. Y'all did great. Group 2.
Okay, so basically this case, this woman was in a car accident, led to a concussion. She sought therapy, started to develop symptoms of depression and anxiety due to like thinking she wouldn't be able to get over it. And then fast forward for almost a year later, the trial's still pending, and the attorney wants to use the therapy information to secure a better financial settlement. Scroll down just a little bit. So this one was a little bit confusing to us as well, but we decided that the fact that the lawyer requested the information to get a better settlement was deceptive. However, we weren't sure if maybe that it was true, and so it would enhance the case, not necessarily for bad reasons or selfish reasons, just because there was more needed. So that was a little confusing.
Yeah, following up, it was mostly about whether or not Dr. Muzzle was going to be completely honest with the courts. 102 protects unethical conflicts under the law. 904 protects Ms. Bash and the other driver from misrepresentation of data. So those two sections kind of help protect both parties from deception in a court case. And then as for what she should have done differently, Dr. Muzzle should have given better consideration to what the information could have been used for. And then also we kind of discussed the possibility of, providing raw data and interpretation rather than testifying to try to prevent bias on the stand. But we all were not 100% positive on whether or not that would be the best course of action or the most ethical course of action. Law's hard.
Yeah, so now we're starting to get into ones that are harder, right? They're not as clear. And CJ did a great job picking these from the ones I sent him. Yeah, so essentially here, the main issue, which you've all started to get at, is that, this kind of puts the therapist in a dual relationship, right? So they're serving as an expert witness and the therapist. And also the therapist needs to make it really clear to the client, if I'm put on the stand, yeah, I can talk about, what you want me to talk about. But, if you give me permission to talk about anything and they put me under cross-examination and they ask about other things in your record, I can't perjure myself, right? So I have to disclose it. And you might not want some of this out there on public record. So yeah, this gets really, really tricky. And, it's often better to sort of suggest at this point, get a separate evaluation specifically for this by someone who's trained to do the forensic evals. And it just sort of creates, again, this really difficult situation for the therapist.
Yeah, because a lot of these that I picked are very, not difficult to understand, but it makes you think okay, what is the therapist doing wrong, or what did they do wrong?
And then for the next case, I actually had to Google it because it was not 100% clear what the case itself was actually about in this little blurb. So essentially there was a psychologist named Polly Ross, and she was counseling a boy who had been dealing with headaches after suffering a fall. The parents decided to sue the York Jewish Community Center because their kid suffered headaches there, and they wanted financial support for that. They had a legal battle in which the records were subpoenaed. Ross released the records to both attorneys, and then later received a complaint from the parents. The Pennsylvania board ruled that Ross should have sought the advice of a counsel before releasing records in response to a subpoena, and then the courts upheld that ruling. So essentially, according to the precedent set in the case that I Googled because I was confused, she should have consulted, even though she was subpoenaed by a court of law, that does not immediately mean that she needs to release all records all at once. She should have consulted the board and an attorney before releasing those records, as well as, according to 404, which is the case precedent, only releasing the minimum amount of information required to achieve the relevant purpose. It's the information germane to the case. If someone else wants to talk about stuff, sorry.
And then, so we said for what they should have done differently, should have consulted the board and attorney before releasing the information, and only releasing the minimum amount of information required to achieve what the purpose. Sorry.
Yeah, so again, quick comment on this. Y'all are doing a great job discussing these. Yeah, I mean, the major issue here is you should see how much you have to release. Yeah, Carly, this is a really good point. I thought you had to release everything you're asked for. You can only release what's relevant. And again, the book that I use for these case studies actually has really nice language here. If they get a subpoena, especially if it's the opposing attorney, the client hasn't told you they give permission for it, you can actually say, because this is true, if someone random calls your office and says, I need information about such and such, you actually can't say, even if that person is your client, unless they give you a release. So You can say, I cannot disclose whether the person noted in the subpoena is now or ever was my client. If the person were my client, I could not provide any information without a signed release from that individual or a valid court order. So, you know, it's harder with a subpoena or like if it comes from the court, but a subpoena is typically from the attorney. And like you have the right to sort of argue with them, and you can essentially try to get to, I'm only going to give you what you need. You know, the client does have to sign a release first. And if they start giving you a hard time, then you can say, okay, take it to the judge. And then the judge will review case law and determine, you know, whether or not you have to.
Would this be done through writing? Probably through writing, because it wouldn't. It'd probably be a lot easier, and you don't know who's like in it. A lot of phone issues, I suppose.
Yeah, most things are still done snail mail for this. Yeah, for record keeping purposes. And same thing for your client doing the release. Typically, you would want an actual signature. There are ways you can have them signed digitally, but for something that's going to go to court, I would say you really want to have them like sign it in person in front of you.
All right, good job, group 2. And group 3.
So this one was very hard. So basically, in this case, there was a therapist who was doing grief counseling for a child that they for when their child died, and they were actually like under investigation for potentially abusing the child and causing the death of the child. And the ethical problem was that the doctor that was treating the couple was asked to testify. However, the judge argued that the therapist should be investigated, because why would they testify now in court instead of reporting potential abuse right away? It was very unclear if the therapist was aware of the abuse, but it was a matter of if they knew it happened, why would they wait to testify in court for it? Like, why not would they report right away? We had such a hard time finding a portion of the ethics code that applies. Like, we weren't sure, but basically what we decided was, like, under various state laws and policies that different counseling services have, is if they have knowledge about abuse, to report to their supervisor and potentially report it to the proper authorities.
Yeah, that one was, yeah, I was in this group as well, and it was an iffy one, because there was a lot going on, especially like dealing with how the judge wanted the forms before, and the therapist didn't want to discuss any of the material from their sessions. And in the chat, Zoe said, can we retouch subpoenas and what they are again?
Oh, subpoenas are requests to come to court, I believe.
Yeah, that's what it is.
So, Yami or CJ, do you have any more comments? Or do you want to move to the next one?
We're kind of struggling on which portion of the ethics code applied here, because we didn't know if it fell under child assessments or the, my bad guys, or the other one.
Yeah, like
the ethics code and stuff, but I couldn't find any. But I think in in 50 states in the US, therapists should report their child abuse. If they're in danger or a danger to others, they should have reported that. So I feel like there's a lot of kids who like get abandoned